Welcome back to Scripps News tonight. In the aftermath of last year's Dobbs decision, where the Supreme Court overturned Roe versus Wade, state courts have had to weigh their own abortion laws. Arizona has two. You heard me right. And today, the state Supreme Court is trying to figure out which one should hold. A law passed in 1864, before Arizona even became a state, banned abortion at any stage of pregnancy. But a court ruling last year blocked prosecution of providers of abortions up to 15 weeks into pregnancy. In practice, abortion has been legal before that deadline. The 6 justices are hearing oral arguments and may soon decide the case. Scripps News correspondent Addie Guajardo is based in Arizona, has more for us.
The decision to overturn Roe v. Wade came down more than a year and a half ago, leaving it up to states to decide if they wanted to implement abortion bans, sparking confusion for women and courts to navigate. And this week, 4 state Supreme Courts are navigating abortion cases, including right here in Arizona. A packed house at the Arizona Supreme Court as justices listened and questioned oral arguments presented on dueling abortion laws, creating confusion in the Grand Canyon state. The court will determine which abortion law will apply to Arizonans. Currently, there are 2 laws in the state, a nearly total ban on abortions, known as the 1864 territorial ban, and an abortion law signed in Arizona in 2022 that prohibits abortions after 15 weeks. They carry different penalties. An appellate court ruling last year determined doctors could not be prosecuted for abortions performed before 15 weeks into a pregnancy. But a petition in August challenged that ruling, and the Arizona Supreme Court accepted a hearing. Planned Parenthood and the Arizona Attorney General are seeking to keep the court ruling, which allows a 15-week law to supersede the territorial ban.
The real-world consequences of this case are huge. Whether abortions will remain legal up to 15 weeks or whether abortions will only be allowed when it's necessary to save the life of the mother.
Jake Warner, the attorney with Alliance Defending Freedom, argues the 15-week law and another pre-Roe law protect life from conception.
We would expect physicians to look not only at the 15 weeks law, but the pre-Roe law to see how these requirements fit together, and certainly clarity will hopefully come from the court, which is why we're here today. We want the Arizona Supreme Court to affirm that life is a human right and uphold the legislative intent to keep its pre-Roe law, protecting unborn life from the moment of conception.
Abortion law supporters are pushing to get the abortion question on the ballot for 2024 to let Arizona residents decide. Addie Guajardo, Scripps News.
And Texas has a major abortion case of its own. 31-year-old mother of 2, Kate Cox, sued for the right to end her pregnancy. She and her doctors agree it threatens both her future fertility and her life. Cox is 21 weeks pregnant. Her fetus has been diagnosed with a genetic condition that almost guarantees her baby will not survive. Cox shared her story in an opinion piece in the Dallas Morning News, writing in part about her expected child, quote, "It isn't a matter of if I will have to say goodbye to her, but when." The Texas Supreme Court ruled against Cox. They said in their view, Cox's doctor, quote, did not assert that Cox has a life-threatening physical condition. Now, Cox has since gone out of state to get an abortion. And in Kentucky, a pregnant woman is filing a class action lawsuit challenging the state's abortion ban. The woman filing under the name Jane Doe is now roughly 9 weeks pregnant and bringing the lawsuit alongside Planned Parenthood. Now, Ms. Doe's attorneys with the ACLU announced Tuesday that their client has since learned her embryo no longer has a heartbeat. They still plan to move the lawsuit forward. Now, it is a legal minefield. States are setting their own new precedent in real time as we're seeing play out. So let's bring in Jessie Hill to help us understand this. She's a law professor at Case Western Reserve University in Ohio, another state with ongoing abortion policy battles, and she specializes in reproductive rights law. Thank you for joining us tonight. I want to stick with the class action lawsuit in Kentucky first. How strong is this approach against a state Supreme Court that ruled against halting the state's near total abortion ban?
Well, thanks so much for having me on. I think it is not only a strong approach, but really the only option that was left there in Kentucky, because earlier the Kentucky Supreme Court had actually ruled not that the state's ban was constitutional, but rather that the plaintiffs who had brought the case, which were abortion providers and clinics, were not the right parties to bring the case, and that they expected to have an individual patient instead bringing the lawsuit. And so now that's exactly what the ACLU attorneys are trying to do in this case, is bring the case with an individual patient as the plaintiff challenging the law.
Yeah. And they're asking for other women potentially in similar situations to join in this. So certainly trying that. Kentucky's abortion ban comes into effect when a heartbeat is present, around 6 weeks. In this case, we've learned Jane Doe's embryo has no heartbeat. Does state law cover this? Does this affect whether she has standing to sue?
Well, there are a couple of things going on here. One is that it's very unusual. In fact, Kentucky is the only state in the country that requires an individual patient to bring these lawsuits. And now we can see why it's a rule that makes no sense. And it makes a lot more sense to let clinics bring these cases because, anything can happen in a pregnancy. Every pregnancy is different. To require an individual, woman to go through this process and then maybe things change during the course of the lawsuit. There's no reason for this. So, that's a very strange thing that's going on in this case. And it just shows why the Kentucky Supreme Court's ruling made no sense.
Okay, well, let's turn to Texas, of course, because this is all very piecemeal. We know Kate Cox has since left the state for abortion care. We wanted to unpack Attorney General Ken Paxton's response to this case. In a letter, he had pointed to the court finding Cox's doctor failed to prove her life was in danger, which is a qualification for the medical exception for her to be able to get the right to an abortion. Texas Right to Life saying in a statement, quote, other medical experts disagree with Cox's doctor's assessment of the pregnancy, jeopardizing her future ability to have more children. If you were legally advising medical groups on how to navigate this burden of proof, what would you say?
That's a really tough one because the courts and the state and the attorney general are all talking out of both sides of their mouths. So on the one hand, they try to say, our laws are not unreasonable. They let doctors provide abortions when their judgment says it's necessary. And at the same time, they're saying, but not here. We're going to second guess this particular physician's judgment in this particular case and actually threaten them with criminal penalties. So there's really no good answer. And no one should be surprised that physicians are absolutely terrified in Texas and in similar states, and that people like Ms. Cox have ended up having to go out of state for care.
And I believe that I read as part of Paxton's statement in response to all of this, something along the lines of Cox's doctor not consulting with another doctor to get a second opinion on it, something to that effect. So just speaking to how complicated it is to be able to even move forward with whatever the new standard is going to be here. Texas enacted Senate Bill 8, and this is going to get really nitty gritty here, but the question is important. A law that really critics call a bounty hunter law, and private citizens can bring charges against anyone found to aid or abet an abortion, potentially even one out of state. The question here being, could Kate Cox's husband or any groups that helped her leave Texas still be held liable?
Well, that's a really complicated question, and there's not a clear legal answer to this right now, partly for the reason that simply no one has tried this, and it would be fairly unprecedented for someone to try it. So we don't have a lot of laws out there to look at for comparison, and we don't have a lot of cases to tell us the answer here. Certainly, they might be concerned that the state would try to go after them on some sort of legal theory because of how broadly the laws are written in Texas.
To that point, when there are so many questions left unanswered regarding abortion law in Kentucky and other states like Texas, as we've seen, play out. Does that make challenging the laws any easier, harder? How do you navigate this?
Yeah, it makes it difficult for everyone. It makes providers afraid to provide reproductive health care. It even makes attorneys nervous about potentially being subject to liability themselves for being involved in these cases. Under Texas's SB 8, there's even risk for attorneys in some cases. And, if you can't find physicians willing to provide care and you can't find patients who are able to, bring lawsuits, wait it out, undergo risks to their health, wait and see what happens, file a lawsuit, work with an attorney, you're just not going to be able to bring these lawsuits anymore. You're just not going to be able to challenge them. And I think, it's not a stretch to say that might be partly by design.
Jessie Hill, law professor at Case Western Reserve University. Thank you so much for joining us and sharing your insight on all of the moving pieces here that we've been following. Appreciate it.
Thank you.
Now, straight ahead, if you have 1 million people to buy for, but not $1 million to spend, you'll want to stick around for our next story. We have the must-follow rules to regifting. Yes, that is next.